We talk about workers' right versus employer power. Looking at it legally, what would you say that an employer need to know as far as their rights are concerned, or employee?
Okay. So I think with the power, it's the employer who has the power.
Yes.
But when it comes to the rights, the employee has been protected by the laws, the Kenyan labor laws, like, for instance, the Employment Act, even the Constitution of Kenya has protected the employee in regards to their rights. So that's why it's important for the employer to know the employee rights to ensure they are not infringing on them, because of course it normally ends up to them compensating employees who end up going to court. Yeah.
So that we can just get it out of the way. So is the employer also protected? Because like I started by saying that sometimes we've had cases where employers feel like they are exploited. If, for example, maybe an employee is saying just false things, if at all, maybe they are declared redundant or maybe their contract is terminated, just issues between employer and employee. So is the employer protected?
Yes, the employer also is also protected but most of the things lie on the employer. For instance, if there is an issue for maybe an employee is claiming that they have not been paid their salary, the law under the Employment Act assumes the employer keeps records. So if the employee is saying they have not been paid, if as an employee you have kept records and you present it, let's say it's before court, and you have evidence to show you have been paying this employee their salary, at least now you have protected yourself as an employer. So I think sometimes employers, maybe they better themselves by not, like, for instance, keeping records, or for instance, having a contract. Because, you know, sometimes an employer might feel like not having a contract protects them. But remember, in the contract, you state all the terms that you have. It protects both parties. So in case of anything, like let's say, for instance, a fixed term contract that's supposed to end in December 31st, December 2026. As an employer, if you made it clear in your contract that the contract ends in December, at the end of December, you know, the employee cannot come and claim that, you know, they thought their contract is continuing for the next year. So the employers also have their rights, but now most of them, I think because I think the power that comes with it, or maybe they don't understand the law. That's why you find in most instances, the court will always go. I normally tell people when we're in court and the employee is claiming they are not given house allowance, and the burden shifts to the employer to bring records. If they don't bring records, the court automatically states that gives the employee the house allowance, because now it's on them. That's why I feel they are protected if they keep records, and of course if they have contracts, they ensure they protect themselves.
So evidence is important all the time.
Yeah.
Do you think workers in Kenya really understand the rights that they have, or is there still an information gap?
There's a serious information gap. Most people don't understand their rights under the Employment Act. As much as these laws have been put to protect both parties, you find for instance, the employees don't know their rights to, for instance, you have a right to have at least, you can't work for the 7 days. You're supposed to rest at least for one day of the 7 days of the week. You have a right to leave days, a minimum of 21 days leave. You have a right to, but most employees normally don't know. Even there's minimum wage that the law provides, but most people are not even aware of how much the minimum wage, especially for the unskilled, it normally applies to the unskilled workers, the casual workers. Most of them don't even know. Like, if you don't know as a watchman that my minimum wage is, I think according to the minimum wage, it's around 17,000, but you're being paid 10,000. If you don't know, like, it will mean that you don't know even your right is being infringed. Yeah, there's serious misinformation, because sometimes when you share maybe content online about employee rights, someone will come to your office saying, I didn't know my rights had been infringed. It's until you shared this. Yeah. So that's why I feel there's that serious gap. Yeah.
So when you talk about sometimes, and you've mentioned a lot of things, but I want to start with this. When you talk about sometimes, the minimum wage gives 17,000, but somebody is being paid 10,000 Kenyan shillings. What recourse do they have? You know, can they go to maybe the employment and labor courts to just, you know, petition for their rights, if that's something that is possible for them?
Yeah, so I normally advise, if you're still, you know, it depends, if you're still having the employer-employee relationship, you can go to the labor office. And now most of the time, most labor offices, your nearest labor office from where you're working, and then you let them know that you're being paid below minimum wage. And most of the time, the labor officers will reach to your employer, yeah, and bring out that issue, and now, of course, negotiate for you to get your normal wage. Then now, most of the time, what happens when now someone has been terminated is when now, especially now maybe a lawyer has been involved. Because now if you come to our offices, we'll know you have been paid since maybe you've worked for 8 years. We'll know you have been underpaid. So we normally seek for the underpayment, the back pay. of the underpaid, and the court normally awards it. So long as there's evidence to show you are being underpaid.
Yeah.
So if you're still working in your workplace and you don't want to ruin that relationship, I think normally you can go to the labor office, but according to the law, so if you go to court, your employer is not supposed to terminate your services based on you going to court.
Yes.
Yeah. So, but I would advise maybe the best, maybe start with the labor office. But what also people should know is you cannot do labor and courts together. Those are two institutions that solve employee issues. So you can't go to the labor office, then also do court. If you have decided the labor office route, you have to follow it until the end, unless maybe you're not, let's say you don't get satisfied with the decision, or maybe they don't actually solve the problem, is when now you bring the case to court. Yeah.
So what you're saying is, sometimes when I have an employee, right?
Yeah.
They take me to court. Of course, I'll be aggrieved. I'll feel very sad about it. So I have to still retain them and look at them every day and not terminate their contract. Yeah,
because now if you are to terminate, what will be the grounds of termination? Because remember, under the law, it has to be lawful termination. You have to be there has to be a reason why you're terminating the employee. Your reason cannot be it's because they took me to court. Yeah.
Of course, we'll be talking about the process of termination in details later. But in that case specifically, what if I say that maybe, we're not getting along anymore? Like I feel like, my employee being here, like we have nothing to talk about. You have no relationship. Naona anaweza nimaliza, naona anaweza mmaliza. Such cases. Isn't that grounds for, a termination or just letting go of my employee?
No, that's not. It will be unfair to there has to be a good reason why you want to let go of your employee. But you can decide if you enter into a mutual separation agreement with the employee.
Yes.
But it has to be with consent, and all parties have to be on the same page. Yeah.
You mentioned something quite interesting that I'd love clarity on. That sometimes people work for 6 days and it's okay. So, that in the 7 days that we have, then it's okay to work for 6 days. Sometimes when people tell me that they work for 6 days, I get so shocked. I say, why? Why do you work for 6 days? I think it should be 5 days. Then you get 2 resting days. So the law actually puts it that working 6 days is okay.
Yeah, but it's not mandatory. The law just gives the law has just stated you have to have at least 1 rest day in a week. But now you can decide, you can change the terms. It doesn't have to be, it's not like the Bible, like you have to, but now the law has already said 1 day. You can't go below 1 day. It can't be 7 days. So you can decide to give 2 days. It depends. Now the agreement you come with your employer. Yeah.
It depends with employer to employer.
Yeah, so you can decide. Most even people, I think they work from Monday to Friday. Some work maybe from Monday to Saturday, half day. But now the law states that you at least have to have 1 day. Sadly, there are people who work from Monday to Sunday. Yeah, they don't even get even that 1 rest day. But the law stipulates that you have to work. That's why when you go to sue, if the person who, now our client was working, we have to seek for that compensation where they are working.
7 days?
Yeah, 7 days.
Okay.
Yeah.
So if somebody is
that will be overtime.
Overtime. If somebody is seeking compensation, say they've worked for 7 days, then how is that process done? Like, how are they paid? Is there a minimum amount?
Yeah, there's normally it will depend with your salary and the number of the period you have worked in the company. So there's the way it's calculated. So what you just do, we do a calculation back. Let's say you're earning 50,000 per month. We'll do a calculation of 1 hour. And normally 8 hours working day. So we'll use that calculation to do the math, to bring out if you worked throughout the entire period, or some you may find there's days you didn't work. So it will depend. That's why we'll do just the calculation based on it. Yeah.
Talk to us about some of the sections in the Employment Act that you find that a lot of Kenyans violate in workplaces.
So I think the most common one I can say is Section 42, probationary contracts. What people don't know is Section 42 has been found to be unconstitutional. Before, probation contracts, you didn't have, first of all, the employers normally, under the law, maximum is 12 months. So you start with 6, you can extend to another 6. If you don't either terminate or confirm the employment of the employee during that period, by operation of the law, that becomes permanent and pensionable employee. That's another thing most people normally, they fail to understand it. And normally under the Section 42, right now, it stipulates that you don't need to follow the normal procedure in terminating. You don't need to follow the giving notice and everything. But there's a 3-judge bench that already decided that's unfair. So that's why I normally say as employers and employees, you need to be up to date with the emerging trends with the employment matters. So I think that is the common one. And the other common is that they don't follow the procedures under Section 41 of the Employment Act, following the normal procedure on terminating an employee. Most people forgo that part. So people normally assume it's gross misconduct. Gross misconduct is, for instance, someone comes, like now even in this workplace, drunk. Under the law, it has stated that's a summary dismissal. So some people make the mistake of terminating someone on the spot. The law is against that. You have to give someone an opportunity. So give them a notice to show cause, let them explain themselves, then have a disciplinary hearing, then make a determination. It can be an absconding duty. Like it's obvious this person has missed coming to work. So people normally have the assumption that if someone has absconded duty, you can't, like, it's automatic, you terminate them. But you need to give them an opportunity to be heard, whereby you follow the procedure. I normally give example of cases where you're justified on why you've terminated the employee. Like, for instance, there are cases where, for instance, someone came with forged documents to get a job. It was not in dispute, but now the mistake during the disciplinary process, these people failed. It was even the Judicial Service Commission that was terminating someone who brought forged documents. They didn't inform this person that they're supposed to come with a witness during the hearing. And just that court found that termination to be unfair. So it can just be some minor mistakes that people find to be, like, they see it as it's not a big deal, like I'm justified. And sometimes it makes sense. As an employer, this person has absconded duty. You're justified to let them go, but you have to follow the procedure. So people forgo those procedures under Section 41, Section 45 of the Employment Act. People forgo it. So they don't. And also certificate of service. It looks so simple, but it's an employee's right to be given a certificate of service. Some employers feel it like, I don't have to give it to you.
That is what we know as recommendation letter, or
no,
this is something else?
There's a difference. Certificate of service is whereby if you have worked in a certain company for 5 years, someone just says this person was working as, let's say, a journalist from maybe 2020 to 2026. Yeah, just basically that's certificate of service. You don't have, recommendation letter is not mandatory. You don't have to give someone. You may decide at your own will as an employer. But certificate of service under Section 51 of the Employment Act, you must give it to an employee. So some employers forgo that. Even sometimes, even if you have followed procedures as an employer, and then you just fail to give that certificate of service, that becomes an unfair termination. Yeah, because they are entitled to be given their certificate of service. Then I think another thing people forgo is there was an amendment to the Employment Act 2022. Yes. Whereby you don't need, as an employer, you can't ask an employee to give you, remember before you need all the clearance certificates, the certificate of good conduct. From the law has stated that you don't need, you're not supposed to ask an employee for those documents until you offer them a job. So some I normally still see they advertise and they still make that as a requirement. Yeah, so those are some of the things people ignore, but it's stipulated under the law.
So if maybe a job now advertises that there's an opportunity, but then they're asking for that good conduct, now that you say court had dismissed that particular part, then what can be done now with that? Because at the end of the day, mtu anataka kazi, yeah? And if they do not submit that particular document, then they cannot get that job, or they cannot even make the cut. Then what do they do in that particular point? Do they just upload it to good conduct? Or?
But it's if someone decides to sue them, they can sue them and they'll win. Yeah, because you're not required to ask for it. It's not mandated. It's just that, of course, people will look at, you weigh even the legal fees and everything. So not a lot of people will actually take it upon themselves to maybe sue or something. But even I normally see, someone can just, anyone, I'm just thinking the way someone, it's the law. It's a law that stipulates you can't give out, you can't ask for those certificates. So I normally see, anyway, Kenyans also fall prey to it. So sometimes you still see someone saying that. Because I remember when my sister was applying for some job, then she was telling me this company is saying that they need those documents like immediately before they offer you the job. And then they tell you, we need like 15,000 to get you those documents. So you see now already you're conning, people get, that's even why I think the law was stipulated to avoid people, like a lot of people are being conned based on that circumstance. Yeah, so to answer your question, I don't think a lot of people, of course, will, unless someone is but now it's risky for an employer unless someone takes it, because if someone decides to sue them, they will actually win in court.
Now that we were talking about termination and we're in that particular point, I'd love for you to walk us just in depth the process of termination, how the law, you know, considers is right? Because when you talk about sometimes absconding duty is a valid reason to terminate somebody's contract, then what is exactly the process of termination? There's something else, redundancy, because these are two different things. So start us off with termination, and then we can now look at redundancy.
So for termination, we can use the example of absconding duty. What the court looks at is the substantive why did you terminate this employee? Let's say the reason was absconding duty. So then court now goes to the how. What process did you use? So what normally happens is you have to give, first of all, if there was an investigation and there's an investigation report, you have to give this employee that before the hearing. That's what most employers normally miss. You have to give this person the evidence you intend to use. If there was a whistleblower who came and maybe reported, you have to give and there's a statement that they recorded, you have to give the employee that evidence. So there's the notice to show cause. You have to give the employee the notice, basically informing them there's this allegation against you. So we are giving you, and also the timeline is very important, because the 1 day has been, employment courts have stated that 1 day is not enough for someone to respond. So depending on the circumstances. So you write a notice to show cause to the employee, and then the employee is given timeline. I normally tell people 3 days, 3 to 5 days, depending on the circumstance. Give them, let's say, 3 days to respond to the show cause letter. Then when they do then after they respond to the notice to show cause, now you'll see based on the response, you see if it's justifiable. If they don't give a justifiable reason that you feel you're justified with the reason, you now give them a notice to attend a disciplinary hearing. And you have to, in the notice to attend the disciplinary hearing, you have to stipulate that they can come with a witness. It's under the law. They can come with a witness if they want, or an employee of their choice. And then, of course, you state when the disciplinary hearing is going to take place. Common mistake most employers make, you can't be the one person who investigated and you're the one who will sit in the disciplinary panel. That's illegal. And then you also, if there are witnesses, you have to bring them to be cross-examined. The employee has a right to come and cross-examine them. So that's why there'll be a hearing. During the hearing, the employee will be given a chance to present their case. So let's say it was absconding, they might be saying, maybe I was sick. So did they present any evidence to show that they were sick? And no burden is normally on the employer. That's why we normally advise employees, when you get to this stage, remember the burden is, I normally say the burden is normally on who alleges. So some people normally make the mistake, employees. So now this is just free advice to employees. Some, they feel like, let me fight for my job. So they go and admit even things that they didn't, like they feel being apologetic will give them back their job. Remember, the moment you apologize and everything, it's like you're admitting to that. So the employer's job becomes easy. Yeah. So anyway, it will be opportunity now to defend yourself during the disciplinary hearing. Then now the employer will make a determination. So most of the, but I normally say most of the time, by the time an employer has done this process, 90% of the time it normally ends with termination, most of the time. So after now that you get the termination letter, and you normally have a right to appeal. Most companies have policies which stipulate that you have like 7 days right to appeal. Yeah.
With the courts, right?
No, with them. You know that with their, your employer. You know, you have a hearing and then they'll make a determination. Most employers have policies where they give the employer right to appeal that decision that the employer has made. Yeah.
So when you said cross-examination, that, you know, what an employer is given a chance to cross-examine the witness, we don't see that happening most of the time. What you're saying is sometimes if maybe a colleague of mine has issues with me and they report to me, then I should be put in the same room with them to also ask them questions.
Yeah, let's say for me, I've gone to report you to the now let's say we're working together and then I've reported you. You know, you have a right during the hearing to cross-examine me. What, you know, they can't go with what I've just said and assume it's the truth. Yeah, so that's normally, even those are the mistakes that most employers make. That's why you find most cases, that's why people even assume that the Employment Act has like fully protected the employee, because now because of just, you might have been justified, this person absconded duty even for a month, like it's not even in dispute, but now the fact that you didn't give this person an opportunity to give a fair hearing during the disciplinary process, that's enough for court to find that to be an unfair termination, and the employee will be compensated. Yeah.
So the employee will be compensated such that they will be paid by the company for, say, what, there's a term that they use.
Yeah, there's normally, court will compensate the employee. It's normally, the court has provided the Act provides, Section 49 provides for 12 months maximum. But now court will look at the circumstances. So sometimes if the process was so unfair, court sometimes will give them the maximum 12 months. But if maybe like for such a situation where they were justified on the why, court might give 3 months, 4 months of your salary. So let's say if you're earning 50,000, it will be 50,000 times 4 for the 4 months. And then if they didn't give you a notice, payment in lieu note of notice, you'll get now the 50,000 for the month. Yeah, and then those unpaid leave days, that's when even if the issue of underpayment, that's when it comes in. House allowance, because the law stipulates that you're supposed to provide house accommodation, but now it doesn't have to be like real accommodation. It can be through salary, like they just give you good compensation that includes house where you can get good accommodation. So if it's not been provided, it's one of the things compensation you will seek. This is now in court. So the moment court finds there's no fair termination, they compensate the employee. Yeah.
So I'm trying to think about it this way. Does the court see that as emotional abuse? For example, if the issue of cross-examination, if it's not done at all, and then they see that there was no fair, judgment in the, at work, so does court consider that emotional abuse, or what does the court call it?
No, it just considers unfair termination because the law provides that it has to be a fair disciplinary process.
Okay.
And I normally tell court awards what you have sought for. In most instances, court will not give you what you have not sought for. So if you are claiming that your rights, like now you're saying emotional, maybe of course you'll say your rights under the Constitution was infringed.
Yes.
Maybe right to fair labor practice. That's where you'll have to seek for constitutional infringement compensation for that. But now here for that process, court just looks like they didn't follow the procedure, the disciplinary process. Yeah.
Are there cases where court has ordered for that employee to be given back their job so that they can be retained?
Yeah, if the employer has sought for reinstatement. So if you went to court and sought for reinstatement, court will hear you out, hear the employer, and court now might determine now whether you'll be reinstated to your job. Yeah.
I'm trying to see how now that environment will be for the employee who has been reinstated. Is it always a safe working environment, or do you recommend actually for somebody to go back to that workplace where now, of course, there has been a case, they have taken the employer to court, they have won the case, and now they are back at work? Do you recommend such a scenario?
For such a scenario, it depends with now what is the purposes of why you are leaving. This incident even happened, that you're even in court seeking for reinstatement. But even in most instances, court will look at also the circumstances and the relationship now. If now they think the relationship is no longer fair, for court may not request for reinstatement to be given. And then sometimes, most of the time when you're seeking for reinstatement, it has to be at the beginning. Because remember, I normally tell people cases take like even 3 years. So it can't be something you've sought after the case, after the fact. Of course, this employer will have to get someone to do that job. So that's most of the time, if you're seeking for reinstatement, it's normally something you seek from the beginning, when you're filing the case. So of course, if you're seeking for reinstatement, you won't seek for compensation for these damages because you're going back to, most of the time you won't seek for this compensation because you're going back to work. Yeah. So basically, termination will not have happened.
All right.
Yeah.
And when you talk about this case is taking 3 years, why does it take so long though?
It depends. I think it's courts. Like for instance, if you're filing in 8 million money, they have a lot of cases already. And also sometimes there's the issue of the judges or the magistrates are transferred. So the case takes longer. You may find you'd been given, like for us, we had a case that we had in February. Then we were told the magistrate was transferred. They gave us a date in August. Like you just find in the system it has been updated to August. Let's say you don't have control over it. And then maybe that August, maybe the magistrate will not sit. Then you get you may find when you get in December. So I think sometimes also it just depends with the court. But sometimes also you get lucky, but I don't think it's so rare that you get, most of the time the employment matters have done 3 years. Yeah.
Is pay cut justified? Say, for example, there are challenges at work. Economy is bad, and maybe my employer sees that, now at this point, I don't want to send these guys home, right? What we'll do is that if I'm giving you, for example, that 50,000 Kenyan shillings or 100,000 Kenyan shillings, then I'm going to cut your salary to 50,000. Or if it's 50, I'm going to cut it to 25,000. Is that justified under the law?
First, salary reduction is illegal under the law, but it depends if an employer does it with consultation with the employee. Like now maybe the business is not doing well, they have to consult the employee. Let the employee know that we want to reduce salaries to this amount. And there has to be evidence on their end. There has to be consultation. Yeah, but generally it's normally illegal to reduce an employee's salary without their consent. Yeah, unless they consent, that's okay. Maybe even do a written consent, maybe for a certain period. Yeah.
So what if they're consulted but they're not for that idea? You know, you've given them the reasons why you are for a pay cut because maybe the economy is doing badly for everyone else, everyone is affected. But now your employees are not in for that particular agreement, they're against it. And then you proceed, of course, to just cut their salaries. Then is that something that the law would find illegal?
Yeah, court will find that illegal if you go ahead to terminate an employee's salary. Because remember, if an employee goes and claims their salary was deducted illegally without their consent, burden shifts to you to confirm if you consented. So most of the time, even that's what I was saying, when we do when you are seeking for compensation in court, most of the time when you have sought for salary reduction, if the employer doesn't justify it by saying that there was consent, and there has to be like written consent whereby the employee signed and admitted or evidence just to confirm that consent, the court will automatically find that to award the employee the salary that was reduced. Because remember, this is breach of contract. When you enter into a contract with you, you're supposed to pay me 50,000. The moment you're going against it, that's already breach of contract.
Of a contract. Walk us through the process of now declaring redundancy. How are employees protected in this case?
So for redundancy, by the I normally tell people it's not an illegal process. It's just that how the employer carries it out. Because most time redundancy, it's normally involuntary in a way that maybe the company is undergoing, maybe it's closing up, maybe they're restructuring, or maybe they don't need that position anymore. So that's why redundancy is not but now the problem is an employee is protected if, because normally court requires, there are some processes you have to follow. You have to look at the skill of the employee. First of all, even this one, there has to be consultation with the employee. You have to consult with the employee. There has to be, the employee has to, like for instance, now, you look at the skill set. So we cannot be, let's say for us, we're in the same industry and maybe the company is restructuring and me, I've worked for 20 years. Then for you, they normally say last in, last out. First in, last out. So if I've worked in that company for 20 years and then for you joined a year later, you see now it will be unfair if I'm the one who is my position, I'm the one who lives before you. So court has to look at the process that you followed, the procedure that the employer followed. Another mistake employers do, I normally see employers when they want to get rid of someone, sometimes they make the mistake of you find for you your position has been declared redundant, like they no longer read your position, and then the next day you're seeing the position has been advertised. Yeah, there's even a case now, normally it's a famous bank, they did the same thing, and the employee was handsomely rewarded by court because there was evidence that that position was advertised after they went for redundancy, claiming that position was no longer needed. So I normally tell people for redundancy, it's not an illegal process. It's how the procedure now is when now the legality comes in. Yeah.
Talk to us about those employees now who choose to terminate the contract. In that case, does the employer have anything against them?
So normally, most of the time you find in the terms of your contract, there's a termination clause whereby it stipulates that each party has to give 1 month notice. So the same applies if it's the employee who wants to part ways. So you give 1 month, maybe you want to resign, if it's resignation, you give 1 month notice to the employer that you're resigning from your position. Most instances, of course, the employer, unless maybe you don't give the 1 month notice, they'll make sick. Though it's so rare for an employer to take someone to court for not giving the 1 month notice, because now you'll pay them. If you don't give the 1 month notice, you have to give payment in lieu of notice. So basically, if you're earning 50,000, if you resign immediately, you have to pay them 50,000 to the employer.
Oh, you pay the employer?
Yeah, because now it's the same vice versa. Just the way if the employer does not give you notice, they have to pay you 1 month in lieu of notice. So even if you are resigning or terminating the contract, you have to inform them. You have to give 1 month notice to the employer, maybe to look for a person to replace that. So maybe, like, if you want to leave the company, let's say, maybe you have made a choice this March, you want to leave. You give them 1 month notice, then you leave now in April. So just give them the notice, then you leave in April. You give them time, of course, maybe to look for another employee. But now if you give a resignation letter that same day and you leave, the employer is justified to seek
to ask for payment
from you.
What if now I work halfway, right? Say the month has 30 days, but I work 15. You give me 50,000 and now I say I'm going to give you 25,000. Is that something that is doable?
Sorry?
Or I have to give you, you're saying that if I terminate my contract or if I resign before, the 1 month notice is done, then what if now I choose to work it halfway, right? I want to resign by April, but I choose to work from 1st to the 15th of March.
Yeah.
So I give my employer 25,000 to let me go. Is that justified?
Yeah, you can compensate because at least you've worked for those 15 days. Yeah, it's justifiable.
All right.
Yeah.